Hello and welcome to this video clip looking at the purpose of employment law. So this particular clip is really relevant to people who are studying employment law, either as part of the intermediate or advanced level CIPD programmes. It's also relevant to anyone looking at employment relations, because ultimately employment regulation will impact the employment relationship, and we'll touch on that as we go through this video clip. So we're looking at the purpose of employment regulation. It's worthwhile considering it from the point of view of the different stakeholders involved. So what I've got behind me is an illustration saying that actually there are really three main stakeholders with employment law. So there's the government, there's organisations or employers, and there are employees, including their representatives such as trade unions. So to illustrate this, it's worthwhile taking a piece of employment legislation as an example. So what I use this exercise quite frequently. What I've got on these little cards are different pieces of employment regulation. So I'm just going to pick one. So I'm going to look at the National Minimum Wage Act, 1998. So that's the legislation that provides the basis for which the minimum wage and now the national living wage is put into legislation. So first introduced in 1998, but of course, as we know, the rates are amended every year in line with government policy and legislation. So if you take a piece of legislation such as that and think about, well, actually, what purpose does that serve to these different stakeholders? So from the government point of view, the government is interested in people having a certain level of income. A few different reasons behind that. If you've been cynical, you could say, well, actually, that then increases the amount of tax they collect. But also, it has an impact on the wider economy. So if people are earning more, they're able to afford a better standard of living. So that will have an impact on things like the welfare system. They also have a more disposable income, so it has an impact on consumer spending and therefore the economy. And also, if you have people who are better paid or there's a minimum level of pay, that also has an impact on things such as people not being exploited. So that links to other legislation such as modern slavery and also right to work. So you know, even if you are from another country, as long as you have the right to work, you get a certain level of income rather than the chance of people being exploited because of low skills or not speaking English as their first language. If you then move on to organisations, so this legislation in particular, this sets the minimum. So it says, well, actually, as an organisation, this is what you have to do as a minimum standard. When you look at, and if you look at certain organisations, so if you're in organisations that pay the minimum wage for a large proportion of your workforce, then it also supports around budgeting. So you know, in that particular period of time, this is the minimum you have to pay people. If you then look at employees, well, this piece of legislation in particular probably has the greatest impact on employees, because it says, well, as an employee, this is the minimum amount you should be paid by law. So it makes very clear in terms of what someone can expect in their role. Like I say, what you can do is you can look at that from loads of other pieces of legislation. So things like the Immigration Act, the Equality Act, Rehabilitation of Offenders Act. That's always gets quite a lot of debate going. But effectively, when you look at the purpose of the law, some themes start to come out. And really, what starts to come out is that the purpose of employment law, certainly from the government point of view, it is around the kind of priorities of kind of social equality, justice. It also has an impact on things like social cohesion. If you look at the employer's point of view, the law is very much about setting minimum standards, so saying, well, actually, as a minimum, this is what you should do. And it then prevents things like exploitation and negative treatment. And from an employee's point of view, it states, well, actually, this is the minimum standard you should expect as an employee. And we look at the wider law and the court system, it then provides a framework through which people can raise a claim. So if they're not treated fairly in accordance with the law, then they have that ability to raise a claim through the court system. So those are the kind of themes that come out of those. Now, what we're talking about here, and the examples I've given here, are for UK-based laws. So laws that end in act. So that determines it's from the UK legal system. You do get other legislation that the source of which is from the EU. So things such as 2P, working time regulations, agency worker regulations, basically anything ending in regulations to directive. And you tend to find that the purpose of that legislation is broadly similar. However, because it's based on something called the Social Charter, you tend to find that the biggest purpose is around employees, it's around protecting employees' rights. So if you think of something like 2P, it's about protecting people's employment in a business transfer situation. Like I say, although we're talking here about employment law, the purpose of the legislation also has an impact on employment regulations, on employment relations. So if you are studying that, it's worth knowing about the purpose of the legislation in order to see how it affects the employment relationship. Okay, hopefully you found that useful.